Okay, in our second Common Law 2 video, I want to introduce you to some pretty ethereal, kind of heady stuff. But it's stuff that actually can be applied on an exam and in practice, so it's important to know. We are really going to have to tackle much more in Common Law 2 than in Common Law 1 the meaning of certain terms that are extremely vague and general, right? You were already introduced to some of this. The term interstate commerce is quite general. So it's not like this is completely new to us, right, in our discussions of constitutional law, right, this whole idea of trying to figure out what the thing means. But as you'll see, so we have to, this is introductory material, right, there are certain, one in particular, but there are certain principles in constitutional law too that really require you to apply interpretive methodologies, right, about how to figure out what the Constitution means when the Constitution uses terms, right, that are not self-defining and are not specific. The words that we're really going to be focusing in on early on here are privileges and immunities, right? You know from the Slaughterhouse case that privileges and immunities has pretty much been read out of the 14th Amendment, but more on that later. But that's a very general, broad term. The term equal protection, right, and especially because it's guaranteed to every person. It doesn't say anything in there about certain types of classifications. It doesn't say anything about ethnicity. It just says every person is entitled to equal protection. So that's very vague in general. But we are going to mostly be paying attention here for the first part of Common Law 2 to the Due Process Clause. This is a good opportunity for me to lay out where we're going with this, right? There are basically three huge topics in Constitutional Law 2 covering individual rights, right? One is due process and what that means, right? The due process clauses of the Constitution. So that's the first part of the course. The second part of the course is going to be focused on equal protection, right? Because that's another huge component of individual liberty and rights. And the last part of this course is focused on the First Amendment, right? A lot of the other amendments you cover in criminal procedure, but we study, speech, religion, and all that good stuff in Common Law 2. So the way Common Law 1 broke into parts, right? Common Law 2 does as well, right? There's due process, there's equal protection, and there's the First Amendment. So you can sort of guess what your essay questions are going to be on, right? There are three components. Okay. As to the due process clause, right, either the one in the Fifth Amendment or the one in the 14th Amendment, right, so each one they're identical. They say that the government may not deny you life, liberty, or property without due process. Each one of those clauses uses the word liberty, and that's the one we're really going to be focusing on here for a while, right, is what does that mean? You hear this all the time, right, people don't have a right to do X because the Constitution doesn't say anything about X. Okay. The Constitution does contain two guarantees of liberty, right? So, although, again, the Constitution doesn't say that I have a right to do a discrete, particular specific act. It does say that I have a right to liberty. It presumes liberty, right? So, what does liberty mean, right? Okay, so let's talk about what I referred to earlier in this video as interpretive methodologies, right? It used to be well settled. It used to be almost just taken for granted that the Constitution is, I remember growing up being taught this, right? That the Constitution is a living, breathing, right, Constitution, that it evolves with time, and that its meaning, right, can adapt, right, to new circumstances and throughout our history. In the 1980s, and it's been an extremely successful effort. An effort began, right, to kind of counter what, I'm going to use the words liberal and conservative here because I think that's fair. Right, conservatives became very concerned that what they viewed as a liberal court was becoming unmoored, right, from constitutional meaning. So what arose was a theory of interpretation or a method of interpretation called originalism. And again, we're going to talk about what these mean, but I also want you to be aware as we talk about these that they're more practical than they sound, right? They actually can be applied. Originalism is the theory or the methodology, right, under which it is assumed that the Constitution means now what it meant when it was drafted, right? And by that we mean what the constitutional text, what the words would have meant to somebody who was reading it at the time it was written. So not necessarily the intent of the founders themselves, right, although obviously it would reflect that. The test is not what was in their heads, because we can't get inside their heads, right? The test is you look at what's written and then you ask what would that have meant at the time. Now I want to throw out some very important dates for you. One is 1789, right? 1789 is when the articles, right, the original articles of the Constitution were adopted, right? The Constitutional Convention was 1787, or was started in 1787. The Constitution was adopted in 1789. So that includes things like the Commerce Clause, right? So that means that the Commerce Clause, right, to an originalist, that's what we call these, to an originalist, the Commerce Clause means now what it meant in 1789. Second important date is 1791. Now, obviously, there's not a whole lot of difference between 1789 and 1791, but, you know, why is that an important date? Because that's the date the Bill of Rights was adopted, right, and added to the Constitution. So, what does the First Amendment mean? What does the Fifth Amendment mean, right? That's all in the Bill of Rights. What does the Eighth Amendment mean? Well, that's different. Strike that. But as to most of the Bill of Rights, right, the question is, what did that mean in 1791? So the liberty clause, right, the due process clause of the Fifth Amendment, right, if you're interpreting the word liberty there, an originalist would say, well, liberty means whatever it would have meant to people in 1791. The third important date is 1868. That's the effective date of the 14th Amendment, right? So to an originalist, the 14th Amendment, whatever equal protection means, or liberty means, right, or property means, right, what those terms mean is whatever they meant to the average person who would be reading the Constitution in 1868. So that's called originalism. The theory here is that originalism stops judges from straying too far, right, from the meaning of the Constitution, and yields more predictable results. This is all very controversial, by the way, in legal circles, but I'm just telling you what the theory is, right? That it yields more predictable results, that it lends itself to easier research, right? If I want to know whether somebody has a right to, let's use the example of abortion, right? If I'm an originalist judge, and I want to know whether people have, right, a fundamental right, a liberty interest, right, whether a woman has a liberty interest in abortion services. If I'm an originalist, I send my clerk to the library, tell them to go pull all of the state statute books from 1868, right, and see how many states banned the practice of abortion back then. And if I find that in every state in 1868 that this abortion was banned, was not available, was not considered something that women were free to do, then if I'm an originalist, that ends the inquiry. Right? There is no constitutional right to abortion. So that's originalism.